Let's bring in research fellow at the Heritage Foundation and former Alabama Assistant Attorney General Alan Mendenhall. Great to see you, Alan. Thanks for joining me.
Thanks for having me.
Let's start with birthright. The ruling affirms the 14th Amendment Citizenship Clause, which has guaranteed birthright citizenship since 1868. Quote, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Let's break that down. I have had an issue with this jurisdiction thereof, and we already know there are exceptions. Diplomats, invaders. What's your take?
Well, my take is Justice Thomas was right, and he wrote an extensive dissent, as you mentioned. It's 91 pages, and it's unusual for a dissent to be longer than majority opinion, but we actually have two. Alito's clocks in at 39 pages. Thomas is at 91 pages. I think Justice Thomas's dissent really ought to be what the majority opinion was, and there's some overlap with the majority. So, for example, Justice Thomas agrees that the citizenship clause was meant to incorporate the common law. He agrees that citizenship turned on allegiance. And he agrees that Dred Scott was wrongly decided and that the 14th Amendment was also intended to repudiate Dred Scott. But what they really disagree on is this notion of domicile. And Justice Thomas believes that, the United States did not claim as a citizen every child born in its soil. The quote by Thomas is something like, pursuant to the principle that children followed their parents' domicile, a child is a citizen of the place where his parents were domiciled. So that's a really important point to this case. And another thing that I would love to point out is if you compare Justice Thomas's writing to Justice Jackson's writing, you'll find which one is the more intelligent. Justice Jackson's concurrence contains a number of howlers. I mean, it's really absurd. She wants to portray the Fourth Amendment as a second founding, which is fine. A lot of academics do that. But she also wants to suggest that the second founding eliminated a caste system in the United States, as if the United States ever had a caste system like, for example, Nepal or India had. It did not. And, of course, from the founding, the Americans were getting rid of sort of the hereditary aristocracy that was so common in Europe. So there are antecedents to what the 14th Amendment did.
Alan, it's not a fair fight between Jackson and Justice Thomas. I mean, that is like a little leaguer playing a major league team. I mean, it's just not the same thing. But before the ruling came down, President Trump posted this on Truth Social. Trump's efforts to reverse birthright citizenship may succeed with or without SCOTUS, the Supreme Court upholding state laws. I want to get to that, but let me first have you address what the president said there. And more importantly, and I really want to get your legal take on this, but I want to move on to the trans issue as well. But first, what can Congress do, given that there are already exceptions made to the 14th Amendment Citizenship Clause? Can they just pass a law and add in illegal aliens?
I don't think legislation is going to do it. I think you're going to have to see an amendment to the Constitution, and there are already people calling for it. So that very well may be what we see next. We know that with the SAVE Act, that 80% of the American people support the SAVE Act. So I would imagine that a majority of people probably support a constitutional amendment. Now, we'll see if that's something that Congress has the stomach to actually push.
Yeah. Alan, real quick, Supreme Court did uphold state laws banning biological men and boys, regardless of how they identify, from competing on female school sports team. What are your thoughts on that? And does that mean there will be more lawsuits that are coming down the pike?
I suspect there will be more lawsuits. I mean, this one dealt specifically with men playing in biological women's sport, biological men playing in women's sports. But I suspect we'll see this carry over into a number of other fields. And I'm actually really happy to see this because I'm tired of seeing sort of Derridian deconstruction and Foucault and all these humanities critical theorists being imposed on legal categories. So this notion that gender is performed and not innate, and that there are no pre-existing gendered selves, and that sex categories are just shaped by social norms. They're not biologically assigned. Somehow this made it from humanities departments into our legal system, and they're really absurd. They're not based in science. They're not based in biology. And so it's really great to see the court issue an opinion here that recovers some sense of reality.
Yeah. A little common sense. Alan Mendenhall, great to see you tonight. Thanks for joining me.